It is 5 minutes past the hour of 2. Karibuni, bienvenue. Uh, Welcome, ladies and gentlemen, to our webinar this Monday, 18th of March 2024. My name is Gabriel Achaye, and I'm speaking to you live from Arusha, Tanzania, at the Secretariat of the East Africa Law Society. And on behalf of the East Africa Law Society, we are excited to have you for this session, and we would like to thank you for your continued participation and your continued support for our webinar sessions, which are held every week. So this webinar session is a very special session, and we'll be discussing new age corporate governance, and we'll be navigating the emerging trends and opportunities for you, the legal practitioners in this field. This afternoon, we are honored to have distinguished panelists who will be moderated by a lady of valor. Now, our moderator this afternoon is a lecturer of law and advocate of the High Court of Kenya. She is also a partner at Dr. Musikali Advocates LLP. She also serves as the chairperson of our corporate law committee. Colleagues, ladies and gentlemen, please allow me to introduce Miss Elizabeth Musikali, who is our moderator for this afternoon. Elizabeth, good afternoon, and how are you today?
I'm fine, thank you. Thank you so much, Gabriel, for that very nice introduction. And yes, I'd like to welcome everyone to today's session on corporate governance and emerging trends. I can go ahead and introduce our panelists for today. We have a very distinguished panel, just as Mr. Achaye said. Some of them were not able to join us at now, but will probably be able to join us during the session. So with us today, we have Mr. Arthur Ingeria, who is from Kenya. He's the senior partner at Igeria Ngugi Advocates, and a prestigious law, which is a prestigious law firm situated in Nairobi, in the Republic of Kenya. And additionally, he has had an illustrious career in Kenya, spanning several decades. And in his legal practice, he specializes in civil litigation, arbitration, mediation, conveyancing, probate and administration, and corporate and commercial law. And he's also a certified and practicing company secretary and a trained governance expert. Additionally, he's a member of the Institute of Certified Secretaries, and he's a director for the Center for Corporate Governance, which is CCG. And he's a trainer in the corporate governance courses offered by the center. As well, Mr. Igeria is a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators. He's highly regarded for his exceptional accomplishments and knowledge in alternative dispute resolution. And he was the first chairman of the board of directors, of the Nairobi Center for International Arbitration, NCIA, from 2017 to 2023, after his appointment by His Excellency, the former President of Kenya, Uhuru Kenyatta, in 2017. So he's also a director of the Chartered Institute of Arbitrators of Kenya, which is the Kenyan branch, where he also serves as a tutor for arbitration courses offered by the Institute, and is an accredited mediator by the Mediation Accreditation Committee of the High Court of Kenya. Karibu sana, Mr. Igeria.
Thank you very much.
Yes, our second panelist is Mr. Ian Mutibwa, who is joining us from Uganda, and he is the managing partner at Signum Advocates, and he heads the tax, banking, and finance and corporate governance team within that particular firm. He's both trained in Uganda and the UK and has more than 10 years experience in practice and within this particular field. And in 2016, he was seconded to the global law firm of Latham and Watkins LLP in the UK, in the international tax and project finance departments, with a special emphasis to the African market. And this was under the International Lawyers for Africa, that is ILFA program. And he has twice been nominated for the award of Partner of the Year at the Africa Legal Awards of 2020 and 2021. So he was also recognized amongst the 75 highly regarded business lawyers in Uganda, and he's a member of the East African Law Society and the Uganda Law Society. Additionally, he's a licensed insolvency practitioner in Uganda. Welcome, Mr. Mutibwa. Now, our last...
Thank you very much.
Yes, thank you. Our last panelist for today is Mr. Jean Nepomuchen, and he is from Kigali, Rwanda. He's the managing partner of Landmark Advocates, which is one of the leading law firms in Rwanda. That particular firm is an independent and full-service commercial law firm, which has been in operation since 2016. And they practice different areas, including corporate and commercial law, technology, media and telecommunications law, banking and finance, labor and employment, intellectual property, environmental law, revenue and tax law, amongst other areas. And he has a massive knowledge and experience in corporate governance, technology, media and telecommunications, as well as intellectual property law. Now, he's also a good advisor to investors and entrepreneurs. And it's in this context that in addition to advising his firm's clients since 2021, he's been a legal advisor to the Rwanda Stock Exchange and the Investment Clinic project, which is designed to support participating entrepreneurs to become investor ready and eventually raise funds for the capital market. Now, there he conducts legal and regulatory due diligence amongst other responsibilities. And he's also a passionate trainer and coach, especially in the areas of corporate governance and telecommunications, technology, and media. And since 2023 December, he's been retained by the Business Professional Network in Rwanda to train and coach his beneficiaries in the area of corporate governance, data and privacy protection, and corporate finance. And prior to joining the Rwanda Bar Association in 2013, he worked as a facilitator of the entrepreneurship program at Digital Opportunity Trust in Rwanda between April 2021 and February 2022. He's also a radio producer and a presenter of a law program at the University of Rwanda Salus radio station, that was between 2008 and 2010. He's an advocate of the High Court of Rwanda and a member of the Rwanda Bar Association, EALS, also a private notary and an insolvency practitioner. Right. Karibu sana, Jean, to today's session.
Thank you. Thank you so much.
Right. So you can see we have a very robust group today, and they're going to be able to give us a lot of insight into this area of corporate governance. Now, to our attendees today, I'd like to encourage you to use the chat box where you can keep on making comments throughout the session. And in case you have any questions for our panelists, you can put them up through the Q&A segment of this particular webinar. And at some point, the panelists will discuss these questions or handle the questions either during the session or at the last 20 minutes or so, where we have a plenary discussion. Right, so let's just get right into it. And we will start with our first question, just to lay a foundation on what we're discussing today. And Mr. Mutibwa, what is corporate governance and what are the themes that we're going to be discussing today? What are these new themes that are emerging in this field?
Thank you very much, Elizabeth. I think I'll turn on my camera so that you can easily see me. Good afternoon, panelists and also the attendees. We're happy that you managed to create time to come and join us for this particular discussion on corporate governance. Corporate governance is an interesting creature because most people think it's a creature of maybe 2018 when the global international financial crisis happened. I would argue on most times that is when corporate governance came to the forefront of discussions, when the Lehman Brothers were collapsing, AIG, people got to realize that there's need to actually enforce different practices for companies. But corporate governance had been present from the 1970s. It's just that it was not yet at the forefront on how businesses should run. And corporate governance generally means the systems, the rules, the practices, the processes by which a company is directed and controlled. So corporate governance generally is a system of rules, practices, processes by which a company is directed and controlled. Now, you realize that I've used a couple of things as rules. Those can be set in stone in regulation or in different acts. Then there's processes and practices. These vary according to jurisdictions, but they also vary in accordance to the industry and accordance to what the company is, what business the company is doing. So it's not a one size fits all that this is what corporate governance is. It's just a system of rules and practices, and this can vary depending on different countries. However, we need to appreciate that corporate governance is not just an opaque or something that's inanimate. It is something that has principles that govern it. One of the principles of corporate governance is transparency. Now, transparency is a principle that comes in because of the way companies are governed. Most times people want to hide things under the rug. Corporate governance is coming to say, no. We need to make sure everyone knows what's happening at any one given time. So transparency is one of the different principles that corporate governance hinges on. The other one is accountability. How accountable is a board to its different stakeholders? Do they know what the board is undertaking? Do they know what direction the company is going to do? Do you account to the employees, to the regulators? Do you account to the customers, to the community? How do you engage those people to account with what you're actually doing? Then there is also fairness. So as you're doing all this transparency and accountability, is there fairness? And the most important, which people usually hinge their sights on, is risk management. How do you then manage the risk that face the different businesses, the different industries under corporate governance? Remember that corporations are established mainly to create profits for shareholders. But as you're generating the profits, you must ensure that your stakeholders, well, the different people, the investors, the regulators, the employees, the clients, and also the community that you're in, is not affected by your profit-driven drive, but also they benefit from the company that is doing the different economic activities in that particular region. So it's a blend of interest between the company's profitability as giving back to shareholders vis-a-vis the other stakeholders in the business. Now, again, I told you that this comes into our forefront in 2018 when the financial crisis happens. Then you get to realize that a collapse of a bank like Lehman Brothers, been around for a while, can have a massive implication to people's livelihoods, to the community, to the stakeholders, to the employees. It has so much that it puts into consideration that just neglecting all those aspects, you may actually have a collapse of an economy. So corporate governance comes in to correct those particular aspects that sometimes people who are doing business like us just tend to forget and just want to move forward with just the aim of making profit. So make profit without collapsing the next door neighbor. Okay, that is in a nutshell what corporate governance is about. We can break down any of those things: accountability, transparency, risk management. They're all broken down into different topics. You can have a discussion on your accountability, on your transparency, or risk management for corporate governance. But for purpose of this audience, to help you understand and appreciate what corporate governance is about, it is basically you have a company that needs to make money in a community. So how does that company survive in that community vis-a-vis the regulation around it? That is the single most important use of corporate governance. And the people charged with corporate governance are none other than the directors of a company. This is because the directors under common law, I think most of us are common law country. I think even Rwandans are now common law countries. Most of the common law principles that the directing mind and will of a company is enshrined with the directors. So directors do the day-to-day management and also make decisions for this inanimate thing called the company. So corporate governance is essentially a tool directors use to manage the different stakeholders of the business. Okay, having appreciated that, remember it's a set of rules, processes, and practices. I tend to argue that the law always follows a commerce. The commerce always goes ahead of the law. So you'll never find a situation where laws are changing when commerce is static. Commerce first changes, then the law always catches up with those changes. I'll give you an example. We're in the age of the fourth industrial revolution. That's a change in commerce. Right now, laws being discussed are laws that govern that fourth industrial revolution. Data mining, data privacy, secrecy, and all those other things, because the laws now follow that particular commerce. It therefore follows that even corporate governance will follow the emerging trends of an industry, of a religion, of a region, of a jurisdiction. So it is not a one size. You don't borrow the UK code and bring it to Uganda or bring it to Kenya. You have to understand what the Ugandan market is about. Now, the emerging trends you have seen in corporate governance, I'll start off with the most obvious that everyone keeps on singing, and I'm sure you've heard about, is ESG. That's the economic, social, and governance. ESG plays so much in corporate governance that people are saying, let's not just have companies making money and going away. Do they care about the economy? The economy? Do they care about the surroundings that they're in? Do they care about the society that they're in? Do they care about the governance aspects? So one of the emerging trends is ESG. It's discussed in most boardrooms that I sit on. It's discussed in most M&As that you actually want to undertake. They're looking for your ESG policy. What's your policy on ESG? So the board needs to be aware of this trend and advise the company or advise the management on how to implement ESG strategies. So that's one of the emerging trends that we're seeing in the market. The other thing is AI and technology. Of course, we've seen the rapid rise of ChatGPT in 2023. After 2020, moving forward, we see meetings that are now online. You can have a discussion where we have Rwanda, Kenya, Uganda, Tanzania, and all of us are online. The online movement of technology and artificial intelligence has taken on the center stage, and corporate governance cannot be missing that center stage. We're always mining data. We're always getting people's information. We're always asking for people's identification. This becomes a risk to the company because, it becomes a risk to a company because you have issues of privacy and protection of people's data. Once there's a data leakage or you collect people's data and it leaks out into the public, lawsuits are going to come up. So corporate governance needs to look at how do you incorporate information technology in your business to create efficiency. Remember, it's about getting profits for shareholders. Create efficiency, but at the same time, not jeopardize or not compromise the company information and data. So ESG, AI are emerging trends in corporate governance. The other one that I see happening is diversity, or what we call path to parity. Path to parity is a little bit of a debate in Africa. When you look about now the challenges for Africa, path to parity means that your board needs to be as diverse as possible. We're in a global economy. We don't have any more Kenyan company only having Kenyans. You have Rwandans, you have Ugandans, you have South Africans, you have people from the UK and Americans. So they're asking, how inclusive is your board to cater for the different stakeholders that you have? Okay, you have a Rwandan who speaks French and English as a second language. How do you cater for them? You have a generational pool. I was looking at the population in Uganda. Sorry, I will limit my examples to Uganda because that's where I am. The population of Uganda is majority, most people know majority under 35. But I want to break it down for you a little bit further. Majority of Uganda's population, that means the biggest number of people in Uganda are between 0 to 4 years. There are about 14 million Ugandans between 0 to 4 years. I call them COVID babies. So people are busy in COVID. So 0 to 4 years, you have COVID babies. So the question that you're asking is, how inclusive is your board to cater for that biggest population? Do you only have the analog people? I call them, I won't use terms that I keep using in my trainings. The analog people, they only want to have board papers in paper. They want to have meetings physically. They don't understand these things of digital. Or do you have a mix of both analog and digital people? Do you have a succession plan? Do you have a cultural blend? Or you have only the Chikuyu sitting in the boardroom? Only the Baganda sitting in the boardroom? Do you have a cultural blend? Do you have a gender blend? Now, gender is where the sensitivity comes from, because gender is now as fluid as 34 genders. So do you have that gender blend? Again, remember, it's a set laws. So some laws may not allow for that gender blend that other laws provide for. So you need to understand what regulation you're actually playing in. But path to parity or diversity is one of the cores or the different trends that are happening in corporate governance as we speak. The last one I'll touch is exciting, but I think it's long overdue, and that is what I call a change from private to public. What does that mean? Most times, corporate governance is geared towards public entities. So your publicly listed entity or your public entity having more, in Uganda, is having more than 100 shareholders. They say you must have a corporate governance code. But for private entities, on the other hand, they say, look, we can't govern what you're doing. Do your business the way you want to do it. We can't govern that. But more and more often, I'm seeing a trend where private companies, on their own volition, are now taking on corporate governance practices as if they're public companies. This prepares them for one, venture capital investments or private equity investment, because they're looking for those companies that are well structured under corporate governance. So many of the private companies have now learned that even if we're a family-owned business, we need to have independent non-executive directors to direct us on this particular thing. Or we need to have an audit committee or a risk committee to help us manage the risks that come along with our business, even if the law does not require us to have those particular things. So corporate governance has now moved from, in Uganda, it was what we called mandatory and optional. The optional was a private company saying I can opt out. It has now moved to more mandatory and less optional, because every company that sets up now wants to have a good corporate governance practice. So in my opinion, maybe there'll be others added onto the panelists. My opinion that those broadly are the trends that happen in corporate governance, and most boards are more inclined to follow that particular direction of what do we do with technology, what do we do with diversity, what do we do with the ESG and ESG principles, and also I'm a private entity, but I want to act public so that I can be able to attract the right investments for my business. Thank you.
Right. Thank you very much, Mr. Mutibwa. That was very good and very in-depth. It has laid the right foundation we need for the rest of our discussion. And I'm just going to jump right into the issue of the growth of the use of technology in our society today. Like, clearly, we're already using technology even in this webinar. But now we'll jump into the issue of digital governance. And I'll ask Mr. Jane Nepomuscent to take us through this area of digital governance. Are there any legal frameworks in East African countries that deal with issues of data privacy, cybersecurity, electronic communications? Are there any risks that have been identified or come up when you are adopting these solutions? And what is the impact of that on companies?
Thank you so much, Elizabeth. I think maybe before we tackle the issue of digital governance, we should first of all understand what digital governance is and what it takes to have it in place. First of all, digital governance should be or would be defined as a framework that sets rules and practices for establishing the accountability, the roles, and the decision-making authority for an organization's digital presence. It's like now every company, or every serious company, if I may put it like this, is trying to be online or to be present online. So that is where the digital governance comes in. But before crafting your digital governance as a company, we have to understand this issue in a global way, thinking of our respective countries which are parties to the East Africa So what you have to have in mind is that before you even think of digital governance, you have to think of other aspects or other things that should be put together before you can even reach to that point. Here, I'm trying to talk about, first of all, our respective countries. Do they have, for instance, the digital public infrastructure, DPIs, which would include, for instance, the internet coverage, having data centers, and any other things related to taking services or products from the analog way to making them available online or on the internet. And then, in addition to that, you have to think of the actual access to internet by the population. Do our respective populations have access to the internet? Because there's this rollout of building internet infrastructures, like you will find out that first we have an issue of its name. It's been referred to as digital divide, where you will find out that in many urban areas, people can access internet easily, while in rural areas, it's very hard to access to internet. Then, if your population has access to internet, does it have the right devices? Do our populations, do our citizens have the right electronic devices to access the internet and the services? And then you also have to wonder about the right skills. Do we have skilled people to design or to deliver those digital products or services? Do we have, in addition to the skills, do our organizations, private or public, have a digital presence? So are they willing to serve their beneficiaries through online platforms? Then if everything is like okay, then you have to have as a country or as a region, we have to have then the digital governance components. That's we have to our countries or our respective countries or the region as a whole should have or must have a digital strategy. We should have digital policies. We should have digital guidelines and define our digital processes. So when everything is then put together, that's when you can think of a real digital governance. And as you mentioned, then you can't have a real digital governance if you don't have legal frameworks. What you will find out is that at least every country in the AEC will have scattered laws touching on this aspect of the digital governance. You will find out, for instance, at least each country has an ICT law, a telecommunication law, and so forth. But the most trending now is the data and the privacy protection, and that's where the like the most pressing issue now is because you will find out that a few countries now have specific laws regarding the data and privacy protection. I've been looking around and found out that most of our EAC countries have enacted data and privacy protection laws. I can name, for instance, Kenya, Rwanda, Somalia, Tanzania, and Uganda. They do have specific laws or specific acts regarding the data and the privacy protection. And countries like Burundi, DRC, and South Sudan don't. So they are yet to have their specific laws regarding data protection. But you will find out that in other kinds of law, like criminal laws, like laws punishing cyber offenses, you will find out that some laws like that one, they have some provisions regarding the protection of data protection. And also, for instance, in the banking sector, in the health sector, they have some laws which are like sector specific concerning the protection of data and the privacy protection, but they are yet to have specific laws. Then coming back to the digital governance, if we are talking about corporations or companies, it means that they should in relation to the corporate governance, a company is like building a product or a service and making it available online. And then for building like an online platform or an online solution, companies will need to use, for instance, the data and personal data. So before we can go on, you have to have in mind the difference between data, personal data, privacy, such terms. When we are talking about data, we mean any kind of information. But when we talk of personal data, we are meaning information that you can use to identify a natural person. That is when it becomes then a personal data. And that is where the laws comes in. So if you are building a solution, it means you might need, and in most cases, you would need to use personal data. And if you are using personal data, it means you have to comply with the provisions of the law. And that is when that's where the risks can come in, because when you check our laws, even if you don't check our laws, but you just consider the universal principles of protection of personal data, one of the principles lies in the rights of the data subject. I mean, the data subject here means the person to whom the data is relating to. So if one of the principles is that before you use or you collect a personal data or a piece of personal data, you have to have the consent of the data subject. So if a company then is building solutions and is like using or collecting the personal data of people, they must understand the risks involved. And before working on it, they must put in place ways to comply with laws. And the main issue here then is our laws, we as EAC, we don't have like a harmonized law. Each country has its own act or law, and then when you read them, you will find out that apart from the principle of territoriality, they also have like a principle of nationality. Here, I want to mean if I have a company in Rwanda and I'm trying to collect or to process personal data of a person who is like in Uganda or Kenya, I will need to consult the laws in those 3 countries, because each country or each country's act protects its nationals. That means that is where maybe the big risk is, because you can violate the principles, or because you don't even know them. And I think that is when or where the job of the lawyer comes in. If you are, I think it's a challenge, but it's also an opportunity for us, because that is when we come in. So we as lawyers, we come in to advise our respective clients how they can abide by such laws. And not only that, because we also have to, or we need to help our respective clients to build like structures or to build practices that will fit in with the laws. Here, I'm trying to say, for instance, you companies or those organizations which are trying to come up with some digital solutions, they will need to involve us in the beginning. They will need to involve us in the beginning, because we are supposed to be the ones who understand better the legal implications. So they should, when they are building their solutions, we should be involved from the beginning until the end. And then when a solution is done, we will also still have the role to play. For instance, if you have a company which have a digital presence, it will need to have the privacy terms. That is when a lawyer is needed. They will need, for instance, if you have a company selling online, that same company will need to have some rules, like, for instance, the refund policy. You are buying something online, and sometimes you don't like it, or it has some defects. You want to send it back to the seller, and you have to know the refund policy. That's the document to be drafted by a lawyer. And also another opportunity here is at least referring to our law, each data controller and data processor must have a data protection officer. Maybe I need to define a data controller and a data processor. A data controller is someone who determines the kind of data to collect and how it will be used. Then a data processor is someone, it can be a company or an individual, who has an agreement with a data controller in order that the data processor will assist or will process the information or the data on behalf of the data controller. In other words, you can't be a standalone data processor if you are not working for a data controller. So what we play our role here in these all processes, we assist our clients to first know whether they are processors, just processors, or data controllers. And as I mentioned earlier, at least in accordance with our law, I mean the Rwandan law regarding the protection of data and privacy, each data controller or data processor should have a data protection officer. And our law was very specific that a data protection officer can be an in-house or an outsourced person, which means that lawyers have an opportunity in this new practice. So I don't know whether I've responded to your questions, Elizabeth, but as my colleague from Uganda mentioned, now the field or the extent of corporate governance is becoming bigger and bigger because we have new or emerging trends, but it's not it's not like a challenge alone, but it's also something which you can exploit as an opportunity, at least for lawyers, because as long as we are trained, as long as we have these skills, we are like having more clients, or we are being required more services, then we can make more money. Elizabeth, I don't know whether I responded to your questions.
Yes, thank you very much for that. Now we do have a good idea about the intersection between privacy and cybersecurity and corporate governance, and actually the opportunity that as lawyers we have within the region by getting certified and becoming data protection officers within whichever organization it is that you're operating within. Again, because of these legal challenges such as the transfer of data without proper mechanisms being put in place, the issue of consent, and all of that. Now we'll come back to that, but we need to go on to the next area where we'll have Mr. Ingeria take us through the issue of corporate ethics and compliance. And where does ethics come in this whole conversation? And what are the legal mechanisms which are existing to deal with these ethical breaches and misconduct within our organizations? What role do we as lawyers play in ensuring accountability? Karibu.
All right, thank you very much, Elizabeth. And once again, thank you for giving me the opportunity to make this presentation. Now, the whole conversation surrounding ethics has become very critical in the legal professions, in all of our countries, and this is simply because of the very unfortunate tag that has been placed on lawyers, to the extent that they do tend to espouse very many unethical practices. And there is no doubt that when we look at corporate governance failures or organizations that have failed as a result of non-adherence to corporate governance, we see a direct link between that and their non-adherence to ethics. So we as lawyers have a huge responsibility, one, to ensure that that tag that has been placed on us as unethical is wiped away, and that we are clean of that stain. But two, because we have the responsibility of guiding our clients through many of these issues, we must take this responsibility seriously and preach the gospel of corporate governance in order to ensure that our clients remain compliant and they're able to run their businesses in a way that attracts investors to the region. Therefore, what would we be saying when we talk about corporate governance and ethics governance program? Basically, this is a structure that is designed to ensure that organizations comply with the corporate governance and the legal requirements that come with that. This also ensures that organizations have mechanisms ingrained in them to prevent these violations and wrongdoings and ensure that they remain compliant. Now, because we lawyers understand what corporate governance is, we can be of very great assistance to to organizations. And from the word go, and I'm sure this is a situation in many of these African countries, as it is in Kenya. Anytime that you have a client who wants to set up a company, to create a business organization, they come to a lawyer because lawyers understand the administrative processes of creation of these organizations. Therefore, the responsibility on us as lawyers, as we assist our clients in the creation of these businesses, drafting the papers, the constitution, the compliance documents that would require them to sign and ultimately result in the issuance of a certificate. How do we then help our clients in ensuring that they remain on the straight and narrow? So the several things that lawyers will have to bear in mind as they navigate this process. They can assist by creating and implementing written policies, procedures, and standard of conduct. Okay, now, as you talk to your clients as a lawyer, help them understand that they should have policies, procedures, and standard of conduct in their businesses. That way, when they are faced with a situation that requires them to take action, they can look at the policies and their standards, their procedures, and they can tell their employees or their co-workers that we have these as policies, and this is the basis on which our organization runs. Okay, and therefore we stand by this, and we are designed to operate in a particular way. So, in essence, the lawyer who's creating the documents for a company has the responsibility of creating its DNA, so to speak. Okay, so that corporate governance is ingrained from the very early onset. Additionally, lawyers can assist by providing training and education to their clients on these issues. Remember that our clients are focused on the business for which they have created this business, and they may not have a very conscious eye on procedures and on issues relating to corporate governance. It is our responsibility as lawyers to continually remind them of what to do and how to do what they're doing, so that their company is run and controlled in a way that attracts investors. Lawyers can also help by creating systems for their clients that allow monitoring and auditing of the very many processes that relate to corporate governance, so that at the end of a defined period, an audit is done, and a company is able to determine how compliant they are with the corporate governance principles. So I think, Elizabeth, that in brief would be my answer to your question, and I hope I've covered all the areas that you want me to cover. Back to you.
Yes, thank you very much. I will come back to you in a bit about the same area, but let's go back to one of the themes that was highlighted before by Mr. Mutibwa, which was diversity. And I'd like Mr. Mutibwa to take us through the issue of board diversity. Now, one of the issues that, and I think one of the participants or one of the attendees has raised that, where they want to hear a bit more about diversity. But in particular, let's first talk about what legal frameworks exist within our different jurisdictions regarding board diversity, and how do they impact corporate governance practices? Yes, Mr. Mutibwa, karibu.
Thank you. Thank you very much, Elizabeth, and thank you for that question.
Mhm.
I know when you talk about diversity, many minds go to the LGBTQ communities. And I think the question on the laws that surround diversity in different jurisdictions stems from that. But diversity is far from just LGBTQ. Diversity includes having a well-balanced board. Well-balanced board means does your board consider the generations? We have the Gen Zs, the millennials, the baby boomers, is your board well-balanced that particular aspects, right? It also looks at international mix. If you have a multinational corporation that cuts across 7 jurisdictions, you cannot have board members from one jurisdiction. That also is diversity. The board members should be as diverse as the company operation, because the business in Hong Kong is different from the business in Ghana and different from the business in Uganda. You need to merge the three because your stakeholders are now in a global village. So diversity also includes having international representations on the board. I'll give you an example. I sit on a board which is Eastern Central Africa. Eastern Central Africa, you'll find you have the Democratic Republic of Congo, Central African Republic, they incorporate a little bit of Madagascar. These are Francophone companies, Francophone countries. And the fact that your board should be all-inclusive or diverse means you should also include the Francophone and the Anglophone countries. You cannot have a board that is only Anglophone, okay? In fact, you may play it around with it that say the board chair could be Francophone, the vice chair should be Anglophone. Things like that, you have to create that diversity. But then also, it also includes diversity in as far as you're looking at expertise of the board. You cannot say you run a pharmaceutical company and all your board directors are pharmacists. You need accountants, you need lawyers, you need marketeers, you need procurement people, procurement experts. You need people who manage the risk. Remember, corporate governance is not a one-size-fits-all. It is saying what works well in the industry, in the field, in the country that we play in. And if you have a board, let's say, of a power generation company, you must have an engineer there, right? Who understands power generation, an electrical engineer at that. You cannot have a civil engineer and say, we have an engineer on the board. It has to be an electrical engineer because we're in power generation business. But you should also have someone who is in charge of the legal, someone who can do the HR committees. You must have someone who understands the audit part of it, because you have audit issues and risk issues to look out for. So you need to have a diversity of expertise as well. Diversity of cultures, I cannot emphasize that enough. You need to ensure that if you're an organization like, let's say, a church organization, you need to have different aspects coming into play, different cultures. People have different cultures where they come from. From Uganda, we have over 54 tribes. So you need to say, have I captured the northern part, the southern part, the eastern part, the western part of Uganda to put them into a boardroom? Or is my boardroom skewed towards the central or towards the north? So that also includes diversity. But now to come down to your major question, which says, can we understand this diversity in an African or Ugandan or East African context? The LGBTQ drive has come in very strong on diversity. They're pushing for diversity. But maybe before I get into that, if you go into the Western countries, diversity includes having Africans in the room, having Black people in the room. So it's not just the sexual diversity or the gender diversity. It also includes the culture, which is the Black people. So you find people have Black History Month. People have how many Blacks do you employ in an organization? How many whites do you employ in a Black-owned organization? That also includes diversity. When you come to LGBTQ issues, recently, I think sometime last year, Uganda passed the Anti-Homosexual Act, or the AHA Act as we call it. And it forbade concealing homosexuals or knowing people are homosexuals and concealing them. And one of the things we had to do as a law firm was to advise the different companies that had an inclusive policy, especially from South Africa, they have an inclusivity where they say we can have a board director who is gay, who is bisexual, who is fluid. So they're saying, how does that impact our business in Uganda, where the board chair or the global board chair is fluid? So you need to understand and appreciate that these laws are local laws that affect a company that's multi-jurisdictional. So whereas in other jurisdictions, they accept certain things, in your jurisdiction may not be acceptable. And in Uganda, we're not saying do not be gay. We're saying, look, it is okay for you to be gay. Do not get into habits of recruiting, of soliciting people to come and join your movement. So that what's made criminal is that if you know someone who is soliciting for it, then there'll be a problem. But if you come and say our global chair is gay and flies into Uganda to come and chair a board meeting and flies out, there is nothing wrong with that. So we need to appreciate the different regulations around that particular issues. But for diversity, let's not limit it only to gender. It includes culture, it includes expertise, it includes generational, it includes international inclusion, where you have people from different nations. If you have a Chinese company, for example, corporate governance will dictate that don't only have Chinese directors. Have some Ugandans, have some Kenyans, have some people from the UK, and say this board is so inclusive because our Chinese company is listed on the UK London Stock Exchange. So a UK person becomes in handy. We're operating in Uganda, a Ugandan director becomes in handy. We're a Chinese entity. The Chinese culture must be always emphasized on that board. So you need to have that particular diversity and not just on the gender part of it.
Thank you very much for that. Yes, we'll go back to the discussion on digital governance. And back to you, Mr. Nepomuceni. Apologies if I am massacring your name as you go along. We had talked about the importance of having a data protection officer and all of that, and the issue and the importance of having somebody within the organization that is well versed with data protection, the issue of compliance, etc. But now, what legal risks do companies actually face when they now adopt these digital governance solutions, and what measures can the lawyers now recommend to mitigate those risks? Over to you, Jean.
Thank you so much, Elizabeth. Maybe I had maybe touched on it, but one of the major risks is about the breach of data security, or maybe not even the data security, but also, for instance, you see, when companies are adopting digital solutions, they need either they can use the already available solutions, or they can build their own. So what you will find out, and when you read our respective laws, there is, for instance, an issue regarding the localization of data, whereby each country is trying to oblige its citizen. By citizen here, I include corporate citizens, to have their data stored in their respective countries. And we find such a requirement in the Kenyan Act, in the Rwandan law, in every law. You find such a provision. And then when you are using a solution which has been built by a foreign company, you might find yourself storing your data in the US or in the UK, depending on where your solution provider is hosting their data. So one of the risks is when you are building your own solution, you have to use the existing, or you have to collect personal data. And if you are building or buying that service or that product, then you will run risks like breaching personal data protection requirements, or you end up storing or transferring the personal data that you've collected or processed to or abroad, which is like something which is bad. And it's a big issue because our countries are not aligned on this. For instance, in Rwanda, a company, before, for instance, transferring or sharing data to someone who is abroad, you need a particular permission from the Data Protection Office. And you will find out maybe in Uganda, they might have, for instance, a different requirement. And it's also hard to define, for instance, the transfer. For instance, if you are using Google Drive or you are using another kind of drive, it's maybe hosted in the UK or in the US, and when you access it, because you access it online, so you don't even know whether you are sending data abroad or not. So there is also that issue of like definition, but also maybe other risks can come as the main risk is about, as my colleagues mentioned earlier, the main risks or the main issue is about transparency and fairness, because corporations should maybe be transparent on how they are using our personal data. Is it for building a solution? Are they maybe selling data to their partners to get money? Things like that. So those are some of the risks you can encounter regarding this data governance as long as emerging technologies are concerned. So the role of the lawyer is then to advise from the beginning up to the consumption of the product or the service. And the good thing is that it's like a new area which was born for lawyers, at least in our region. Maybe I will share something. I don't know whether I can be able to share my screen.
I believe you should be able to at the bottom of the screen.
Okay, let me try to share something. Okay. Confirm whether you can see my screen.
Right, we can see it.
Okay. Yeah. So I want to show, as I mentioned earlier, you will find that in our respective countries, there is a requirement of registration of data controllers and data processors. In some countries like Uganda, they also mention other people who are known as data collectors. So the first requirement, the first compliance requirement is the registration. So once your respective clients have been or have complied with this requirement, then the next is to understand what they are required of regarding like what I can mention as post-registration compliance. So in our context, for instance, the first thing that a data controller or a data processor needs is to appoint a data protection officer, and then you will then need to check whether you have relevant documents as a data controller or a data processor, whereby, for instance, you will need to have privacy notices. Those are like forms you need to have in place. You will need to have cookie notices. Maybe when you are visiting websites, sometimes you are required to accept or reject cookies. So if you have a company or a client company which has a website and it's using cookies, you have to have that notice where you can accept or reject cookies. And then you also have to have website terms of use and so forth. Then you will also have some policies in place. That is where comes in the personal data policy, incident response policy. For instance, if you've had a data breach, like in general, you have to communicate the data breach to the regulator and to the affected people. So you have to have all of those policies in place. Another thing that you will need to have is, for instance, there are some other forms that I may call them forms of documents that you have to have in place. For instance, referring to our law, that is regarding compliance. I can call them compliance instruments. For instance, you will need to have a data subject consent form, because as I mentioned earlier, if you are collecting information or personal data, your data subject should accept the collection or the processing of your data, because they have that right to accept or to reject, unless it is in the best interest of the nation or the vital interest of the data subject. For instance, if someone is sick and you're trying to cure him, he cannot say that he will not share his personal information. Then you have to have in place a data subject consent withdrawal form. One of the principles in these data protection requirements is consent. So if someone can give you a consent, he or she has right to withdraw it. So you have to have a form for it. If, for instance, you are collecting the personal data of someone who is a child, or who is mentally incapable, then you will need to have a consent form for the one who exercises parental or any other kind of authority on that person. Then you also have to have a data protection impact assessment register. Maybe I need to have an accent on this. As part of compliance of the corporate governance, as long as data and privacy protection is concerned, each company or each corporation or each data controller or data processor should first carry out a data protection impact assessment, where it will know which kind of personal data they need and how they will collect it, and the risks which are associated to the collection, processing, and storing, and whether they store it locally or abroad. So to have the whole picture, you have to make a data protection impact assessment, and you need to have a register, or you have to document it. And when maybe the regulator comes in to verify, you have to show that you've conducted it. So all these processes or these practices or whatever, it's a role of the lawyer. And it's a way, by complying with this, you are reducing the risks. Elizabeth, I don't know whether I responded to your question.
Yes, you have adequately dealt with that question. You've expanded more on the risks, especially in terms of cross-border transfer of data, and the importance of data protection officers within the organization being well versed with the laws, and also the laws of the countries where that data is going to be transferred, and the risks that come about with that, especially in the issue of the protection of the rights of the data subjects and all of that. Now, I'd like to, and even before we go on to Mr. Ingeria, clearly, as the first presenter had said, we might need to split up all these areas into mini trainings at a later date. But as we go on, we'll get into the issue of the protection of shareholders, and maybe I can just pick Mr. Ingeria to take us through that. We clearly see that there's a bit of a tussle, if I can say that, between the owners of the company, who are the shareholders, who sort of donate their power to the board to make decisions with regards to the manner in which the particular company or organization will be run. Yeah. Now, before we go on, can you briefly take us through how advocates or lawyers can advise companies or can advise, shareholders when they are face certain challenges with regards to the manner in which the boards are running at the companies? So what legal protections do shareholders have in that sense? Just briefly, as we go back to the topic for today.
Thank you, Elizabeth. I think the conversations that lawyers have with their clients or involve a lot of sensitization on their rights and the existence of various laws, especially with regards to what can and cannot be done and what remedies are available to them. Now, corporate governance has institutionalized some very important aspects of protection so that shareholders are not caught flat-footed when things go wrong. But if that happens and they do find themselves in situations where they have to take action against their directors, then various mechanisms exist for them to do so. It's possible for people who are running a company and running it down to be liable for criminal and civil prosecution. And the laws provide for that. I know specifically in Kenya, our Companies Act does have sanctions against directors who breach these provisions, and there are fines imposed and sometimes even jail terms, depending of course on the crime that has been committed, and the provisions also in the penal code in that regard. Our countries also have anti-corruption laws, and in that regard, it is then possible for a shareholder to make reports with regards to instances where they feel that these have been flouted. Organizations, in their effort to comply with corporate governance principles, have also institutionalized whistleblower policies. So one can actually make reports about some of these breaches and remain anonymous, and the information will be given confidentially, and the person who makes the report is treated as a whistleblower, therefore they're protected as long as the information they give is in good faith, and that they're able to verify indeed that information taking place. So that's another protection that is accorded to shareholders with regards to ensuring that these breaches don't leave them completely without anything fall back on regarding their investment. Lastly, there is the element of alternative dispute resolution mechanisms, which I feel I must mention at this point. And these mechanisms are available also because when you're faced with a situation where there is a dispute, it's important to look at the bigger picture, see that the reality of what's facing you is that you have a dispute that requires to be resolved as quickly and as cost efficiently as possible. So how can an aggrieved shareholder ensure that they mitigate their losses? And this would, I guess, would be through employing ADR mechanisms if the need calls for it. And therefore, that way, the losses that have been or are likely to be incurred are mitigated. And lawyers can also be very helpful in that regard. Okay. So back to you, Elizabeth. I hope I've answered your question.
Yes, that was very informative. And let's get then right into the regulatory changes within the East African countries. Are there any recent regulatory changes, Mr. Ngaria, within this particular region that impact corporate governance requirements? And what legal challenges then do companies face when they're adapting to these changes?
Thanks again, Elizabeth. Like my colleague, Mr. Mutibwa, stated when he opened this conversation, corporate governance is not new to us. It's just the codification process that has taken a while to catch up with the practice. But as time has gone on, it's become clear that there is need to put pen to paper so that people can clearly understand the do's and don'ts. And that's where we come up with the statement that you've made, regulatory changes in our countries. And what has happened then as a result of the evolution of corporate governance is that these principles have found their way into the laws through amendments. Okay, so if I could take for instance, the example of duties and obligation of directors. These were preached in corporate governance seminars, and people got to understand them as the duties and obligations of directors. And it did, for a long time, just appear that it was the right thing to do. But now, and I speak especially with regards to my country, Kenya, our Companies Act has undergone amendments that have included some of these corporate governance principles and included them to the extent that directors are required to comply and that they are penalized for non-compliance. Okay? So those are some of the regulatory changes that have occurred. Here in Kenya, we have an organization called the Capital Market Authority, and through its act, it has created guidelines with regards to corporate governance. And through those guidelines, sanctions have been taken against those who are non-compliant with some of these guidelines. Now, some of the consequences of non-compliance, we have seen instances where directors have actually been not just removed from office, but been held as unqualified for holding office in the publicly listed companies. Okay, now that is a huge disincentive, but it's also a huge step towards the cleaning up of the running of companies so that people are able to understand the seriousness with which the role comes. Now, you asked about challenges. If I can say if I were to say there are no challenges, I would not be saying the truth. But if you look at our background as an African country, you do realize that many people understand leadership to be a process that comes with ultimate authority. Okay, whereas corporate governance preaches the distribution of authorities at different levels. Take, for instance, the roles played by a director and a CEO and a chair of a company. So corporate governance principles advocate for the splitting of those roles and the sharing of responsibilities so that there is accountability and transparency in the performance of those roles. Now, for us as a developing African country, and many times people have had a difficulty in understanding this, especially when you look at the era where the chair of a company was the ultimate authority. And it was a monumental task getting people to understand that there are certain things that a chair cannot and should not do for the benefit of the proper running of a company. So those are challenges. Getting people to understand how corporate governance works and getting people who have authority to understand that they should cede that authority for the sake of the better running of the company. Okay. In addition to that, there's still need for development of corporate governance sanctions. Okay, because it's still a developing area. The sanctions that exist are not strong enough. They are not strong deterrent. So many times you'll find that people get away with corporate governance breaches. Okay, and then finally, we live in a society where, like in public companies, you find that people get rewarded with board positions simply because of their political affiliation. But with those appointments, in some instances, and without going into specific details, you find that some of these people have a brief to execute certain instructions. And so corporate governance plays second fiddle to their responsibilities. Okay, so that is a challenge. And I've seen that even when we conduct corporate governance trainings, getting people to understand their responsibilities and the weight of those responsibilities. And many people have seen that as simply a job where they can ease into retirement. So the understanding that this comes with a huge responsibility and that they can actually be prosecuted for their negligence, there's a collective responsibility and all these principles, those are the challenges that we face when you are trying to get people to understand what corporate governance is all about and how these regulatory changes should be implemented in order to avert corporate governance breaches. Okay. Thank you, Elizabeth.
Thank you very much. Thank you very much. So as we are coming towards the end, we're not yet at the end, but we're coming towards the end. I'd like to encourage all of our attendees to keep asking questions in the chat box, and also you can put them up in the Q&A area, and our panelists will discuss them in the last 15 or 20 minutes or so of our webinar today. And one of the last things that we want to tackle today is one of the trends that was mentioned earlier, and that is ESG. And I'd like to probably have Mr. Mutibwa to take us through that briefly, where maybe we can just talk about the area of ESG in terms of how our governments in East Africa are incorporating ESG principles in corporate governance regulations. And now, what is the impact of that on companies, and in terms of risks as well? What legal risks can be encountered as a result of this new area, new trend of ESG principles in corporate governance regulations?
Thank you, Elizabeth. ESG is interesting because it has also been with us. It's just been given an acronym, so to speak. ESG stands for environmental, social, and governance. So they're in essence saying that your company should consider the environment, should consider society, and should consider the governance that comes along with it. So I'll break down ESG from E, S, and the G. Maybe I'll start with the S, because the S is a more friendly part that we've been in. The S is corporate social responsibility. They're saying, look, if you're a bank in a certain place and you're taking billions of shillings per year from the community, give back in a school, give back in employee well-being, give back in financial inclusion, give back in human rights, give back in talent attraction and retention, give back in one way or the other. So all they are saying is that as you are operating in an environment, do you understand community investments? Things like schools, things like hospitals, did you give back to those things? What about the social well-being of your employees? Creating workspaces that promote wellness. Some people now are getting into aspects of hiring a psychologist or psychiatrist at the workplace, having lactating rooms for mothers, giving mothers a little bit of flexi time right after birth. Things like that are what they say. Do you have the empathy for your society or the people who you're working with or the community within which you're operating? If you're in a community that's rural, do you understand that they have to go to the wells? I don't know how many of us know wells, to go to the wells to fetch water. Can you create a borehole that's nearer so that people can access that fresh, clean water? Those are things that talk about on society or social governance. It's your basic CSR, okay? For environmental, they are saying, do you cater for the environment as you're doing your business? I have a client who never wants to take paper receipts. And he says paper is not good for the environment. So he has learned to embrace the fact that paper is not good. Therefore, if you give me a receipt, don't give me a paper receipt. Give me an acknowledgement online. Give me an e-receipt or something like that. Do not give me paper receipt because I don't like it. Do you do things that reduce your contribution to climate change? All right. I know some companies in Uganda that have procured electronic cars for purposes of reducing the emissions that come along with diesel or petrol cars into the environment. What about the biodiversity? Things that are around you. Are you a manufacturing plant that keeps pouring waste into rivers and destroying the flora and fauna in rivers? What about things like the product and services that you have? Are they economically friendly? Are they environmentally friendly? Sorry. Do they actually help to reduce the strain that human beings are putting on the environment? Do you allow people to use paper bags instead of using Kavera or polythene bags, for example, for carrying away things from a supermarket? How do you do in such a way that you preserve the environment? And governance for it goes hand in hand with the things I've been telling you: business ethics, data protection, and security. Things concerning stakeholder engagement, employee engagement, diversity on the board. Those are things that come along with governance. Now, ESG seems colorful and classy up until you start enforcing ESG principles. First and foremost, you must have an ESG policy. What does your policy say about the environment? Do you encourage people to print paper? Do you keep lights on even when the light is on during the day? Must you put all the lights on for purposes of energy saving aspects? Do you give paper for everything that you do? Do you have mechanisms where you've introduced electronic writing pads so that you reduce the use of paper? You know, all those things come in. Your policy has to be clear. The second thing is that you're looking at the cost of enforcement of ESG. Sometimes some companies hire ESG experts to help them with compliance. So you're looking at issues of hiring an expert to help with compliance. You're looking at things like making sure that your employees are well catered for. So you're looking at building lactating rooms for mothers, making sure you get the right health insurance for the team, making sure they have wellness and shrinks and off days and things like that. It's costly for the business. Remember, where I started from is that you're making a business that's entirely run as a capitalistic business to say, can you please care for the people you're actually employing? Can you please care for the environment within which you're operating? Can you care for the people who are running this day-to-day business? So ESG is coming in to look at those particular aspects and to make sure every company complies with the environment or environmentally friendly, the society within which is actually engaged and they work better, and also to ensure that your governance structure is diverse, is all engaging, and it ticks off the boxes that are required for a good governance practice. But before I take leave, I've seen a couple of questions in the chat that are some of them directed to me. If you may allow me to answer some of them. There is one which is directed to me saying, can corporate structure be used in sports? Most definitely. I work for the entertainment and sports industry, and I know that for any structure to work well, you must have a good corporate governance practice. And remember, most of these things are not standing in a vacuum. Looking at sports, you're looking at situations where you're getting players from Uganda going to play in Kenya, or play in Tanzania, or play in DRC. Without a good corporate governance structure, how are you going to structure that particular player coming to Uganda to appreciate that Kenyan dynamics are different? So you need to have those corporate structures also playing in sport. Over to you, Elizabeth.
Yes, thank you very much for that. That was quite informative on ESG. Again, as I said before, we might need to have sort of splinter groups out of this, where we talk about ESG, the issue of ethics, and the issue of the place of digital laws in terms of corporate governance. So as we wind up, I'll go back to Mr. Jean Nepomucene. And my last question to you before we get into the Q&A is, what legal responsibilities do companies in East Africa have towards stakeholders, and how do these obligations influence corporate governance strategies?
Elizabeth, maybe by responding to your questions, I should first, or we should first understand who the stakeholders are, because in a corporate world, where you talk of stakeholders, one may be misled to think that by stakeholders we mean shareholders, because when we normally when we say stakes in a company, we want to mean shares in a company. But this term stakeholder is broader than that, because the stakeholders include not only the shareholders, but also other investors, employees, customers, suppliers, communities, government entities, and trade associations, and so forth. It's like when we say that a company should have, or is rated, or have a relation to its stakeholders, we want to mean that it has some legal or moral obligations to each of such stakeholders. So a company will have obligations to its shareholders, for instance, regarding how they are investing their money, how when it comes to the dividends distribution, when it comes to the appointment of directors and the auditors and so forth. That is when the shareholders comes in, and then a company is operating in a society. I think our colleague from Uganda has put it well by defining the ESG. If a company is operating in a community, the community or the community members are maybe the clients, but even if they are not maybe the clients, they can be affected by the operations of the company in a way or another. For instance, if it is like a mining company operating, or which has mines in Rwanda, maybe its clients or customers might be in China, but the area to extract the mines is in Rwanda. So the surrounding community should be protected in environmental way. If a company is operating, it has obligations to the regulators. I can mention, for instance, a regulator can be the government entity which sets the rules and practice of operations, or which issues the licenses and so forth. But it's not only the regulators, because a company which is operating will be owing taxes to the government and so forth. So all these institutions, communities, and whatever can be referred to as the stakeholders of the company. So if then a company needs to think how it should relate to the investors, employees, customers, suppliers, and government, then it should strategize. It should put in place corporate governance policies that will be in line, or that will be accommodative of stakeholders' rights, or that will accommodate its obligations towards the stakeholders. So as of now, the advanced corporate governance is not the one which considers the interest of shareholders alone, but which also has a stakeholders approach. I mean here, which considers all relevant stakeholders. You can understand that this approach will influence how the company should behave, should be governed, and how and which and what policies should be in place for a better corporate governance. Sorry, Mrs. Elizabeth, I don't know whether I have responded to your question, but
Yes, you have.
Yeah, there is a correlation between stakeholders and the corporate governance. Yeah.
Thank you very much on that. So as we wind up, we'll go back to Mr. Ngeria to comment on now the role of lawyers in advocating for regulatory reforms, which promotes transparency, accountability, and investor protection in East African corporate governance frameworks. You had already laid a foundation on with regards to the regulatory changes in East Africa. So maybe we can finalize with that as we go back to the Q&A. We have some questions for you as well there.
All right, thank you very much, Elizabeth. Our listeners will be happy to know that this is really going to be very brief. What can lawyers do to ensure that there's accountability in that regard? I would say, firstly, because lawyers are involved in from the onset in the creation of these business organizations, they play a very critical role in ensuring that they emphasize on the business owners the need for them to be compliant with these regulatory changes. So at that point, it's important for lawyers to approach the setting up of companies or business organizations, not from a simple textbook approach where you say that all you need them to do is fill out forms, sign them, and submit them to the registration authority, but seek to understand, what does the client want to do? What is their plan? Do they have a vision? And how can you assist them in achieving that vision? And in that process, you can have conversations about corporate governance. In addition to that, setups like this, seminars like this, where lawyers are involved, where they can share their experiences, they can share their wisdom, and they can deliberate with each other on what the situation is, what we can do to improve our society, goes a long way. I'm sure our participants have learned a lot from our colleagues on issues relating to corporate governance, emerging trends, and more of these seminars, holding more of these seminars is a way in which lawyers can play a role in advocating for these reforms. Because we do recognize that despite the fact that we've been having conversations about corporate governance and we're trying to keep up with what is happening even in other parts of the world, we are still not where we'd like to be. And there are still corporate governance failures in different aspects. And so it is important that lawyers play their role in ensuring that regulatory reforms are entrenched and continue to be implemented. The role of a legal advisor cannot be understated, and many of us who are in the legal profession, we do understand that our clients hold us in very high regard with regards to the advice that we give, and particularly because also they're happy to pay us for this advice. So lawyers should then ensure that they undertake significant and thorough research in many of these areas, so that they can also offer advice on some of these reforms, especially in alignment with what's happening in the more developed jurisdictions, so that we can keep up and we can compete effectively in the international market. The legal representation by lawyers is also a way in which they can lend a hand in this advocacy process. And this could either be even on a pro bono basis, where you have a situation where a case meets a significant public interest. So continually educating our clients on the need to keep monitoring and evaluating aspects of corporate governance. That's another way in which lawyers can play a role. Okay? And so those are a few of my answers to your question. Thanks.
Yes, thank you very much. Before you go off in a bit, maybe we can handle one of the questions directed to you from the attendees, where they're talking about ethical dilemmas, which is a big issue in corporate governance. And they say that vested interests play a big role in undermining effective functioning of companies and organizations. So how can one handle an extremely unethical board which has no regard for corporate governance?
Well, of course, depending on the type of organization it is, if it's a publicly listed company, or if it's a company that's under a particular regulator, one of the options would be to bring this to the regulator's attention, and also to highlight this to the attention of the major shareholders in this company, so that they are aware of these corporate governance breaches. Because whether they like it or not, these are threats to their investment, and if they're aware, then they need to do something about it, so that they put a stop to it. I think the auditors also need to be aware of this if they're not, and it needs to be queried significantly at the company's annual general meeting, so that these issues are brought to the fore in various forums in different ways, and those who are affected adversely by some of these corporate governance breaches are aware and are asked to take action. If indeed it does turn out that there is a criminal breach and criminal action needs to be taken, then that needs to be instigated as quickly as possible so that loss is avoided as early as possible. So those are some of the ways in which I think some of these situations can be addressed. Of course, also getting rid of these board members who are believed to be unethical, the revoking their appointments or urging for their replacement and ensuring that they are not reappointed to their positions, so that you have people who are willing to act in the best interests of the company.
Thank you very much for that. We have another question for Mr. Nepomushen with regards to his presentation, where he talked about cookies and whether you said we can either accept or reject them. So one of the attendees is basically saying that they have experienced several platforms where if you don't accept cookies at all, you cannot access the information within that particular website. So what is the purpose of such cookie commands and how can you escape them? I think that is sort of outside of what we're discussing today, but I guess it is still important with regards to our discussion. Yes, go ahead.
Yeah, thank you. Cookies, it's a kind of technology that the owner or the design of the platform will need, will use to collect information about the user, and then we'll use that information to upgrade or to improve the platform. That is in general. But here, companies or platform owners should be transparent, whether they are collecting information to improve the platform or to make it function better, or if they can use that same information for other purposes. So our laws, they say that you cannot collect personal data if you don't have a legitimate purpose or a legitimate ground, and that you should not use the collected or the processed personal data for the purposes other than the ones which you collect it for. So here, when you go on the website and you find they have cookies, normally they should give you options. They should give you an option of accepting some cookies and rejecting them. They should give you an option of what they should, of what they would use your information for. If they're collecting your information for advertisement purposes, for whatever purposes, they should make it very clear and give you options to accept all of them, to reject all of them, or to select some of them and accept them. So if you have a platform which doesn't give you such options, it's not compliant. That platform is not complying with the requirements of the law. I'm talking in the context of the Rwanda because I don't know the other laws in other countries. So it's maybe we have to be aware of that and start maybe being active and maybe give feedback to the owners of the platform or to the regulators so that our rights or the rights of our colleagues can be accommodated with the emerging technologies. Thank you.
Thank you very much, Jean, for that and for highlighting the issue of also the differences in the laws between the countries with regards to that. There's a need for harmonization, especially in East Africa. So the last question we'll take for today is towards or directed towards Mr. Mutibwa, who's been asked to shed light on how East African boards can scale up on diversity and also bring along employee inclusivity, as done in Companies Acts in UK and Europe, where employees are now seen as critical capital alongside financial capital, I believe. So Mr. Mutibwa, kindly take us through that, maybe for a minute or so before we wind up. Thank you.
Thank you very much, Elizabeth. That's an interesting question. One of the things we need to do, especially for the African context, is a cultural shift to realize that the things that we thought were important were not that important. One of the things I always argue as well is that Africa, maybe let me argue for Uganda, not Africa. Africa always leapfrogs or leap jumps. So many countries move forward, maybe 10, 20, 15 years. Then Africa comes and jumps all these stages and jumps into what's required. I know the UK Corporate Governance Code was amended, I think this year, to provide, among others, for an all-inclusive board that has engagement with the workforce. And they provide for the following methods to be used for engagement with the workforce. One, a director appointed from the workforce. So you can appoint a director directly from the workforce. Now you can imagine how that plays along in African private settings. Say you have a director from the workforce. Then two, a formal workforce advisory panel. So you can either have a director appointed from the workforce or a formal workforce advisory panel. And then you can also have a designated non-executive directors for the workforce. Now, these are three ways you can have the workforce or the employees of an entity included in corporate governance and in decision-making of that particular business. One, you can have one of the employees appointed to the board, or have an independent non-executive director who is responsible for the board, or have a panel that represents the workforce, or an advisory panel that represents the workforce. That's what the UK has done as a 2024. I think Uganda or Africa should do the same. But again, it starts with a cultural mind shift where we need to start from to say, do we realize that employees are the backbone of an organization? I'll say this last, and maybe to help bolster why we need to have the workforce part of the panel. If I'll use an ordinary kiosk, if everyone knows what a kiosk is, a small shop. When someone leaves a small shop in the evening, they get the biggest padlock, maybe to lock it up so that their stock in trade stays in. So that in the next day in the morning, they can find their stock in trade there. Maybe textiles or whatever it is that they're selling, okay? For a service industry, which employs people, your stock in trade is your people. And your stock in trade every evening walks out of the business. Imagine if you have a stationery shop and your stationery walks out of the business every evening. And every morning you hope and pray, it's for hoping and praying that they come back. Chances they may not come back, fall sick, an accident, anything can happen. But you hope and pray they come back. How much more should you have these people included in the management and running of the business? Because this is your stock in trade as a service industry. So I think it's long overdue, and we need to actually have an inclusive employee workforce in the corporate governance structures. Thank you.
Yes, thank you very much. And thank you to all our panelists for today for making time. You're all well-versed in this particular area of the law, and you're trainers in your particular countries on this area of the law. And therefore, that's why I keep emphasizing that we probably need to have more in-depth conversations on this with each one of you, maybe in our different countries, or even to have one physical, maybe even paid seminar on this, because it is very important to keep on getting training on this. And thank you for highlighting the issues on ESG, board diversity, the issues on the importance of ethics and what happens if companies or breach ethics. And one good take home on this was about the fact that corporate governance should be sort of like ingrained as the DNA in every particular institution, the place of training, which is what we are actually doing right now, sensitization on shareholder rights, the issue of protection of data, which is very important right now. I guess data is the most valuable commodity today. And when data is being shared between countries, whether within the region or even globally, it needs to be protected. How us as lawyers can now advise companies on protection of their users' data and all of that. And so I'll just ask each of you as we wind up, maybe we can start with Mr. Igeria. Maybe for 30 seconds, what is your parting shot as we move on? Everyone to give us just your parting shot in 30 seconds as we finalize. Thank you.
All right. Thank you very much, Elizabeth. Once again, thank you for hosting me for this webinar. I have enjoyed myself, and I've also learned a lot from my colleagues. I hope the participants have. My parting shot would be that there is every benefit in doing things the right way and avoiding shortcuts. We have seen examples of organizations that were thriving or appeared to be thriving and had created a very, very good business profiles for themselves, and they were the envy of many. But simply because of flouting corporate governance principles, they no longer exist. And that in itself is an example that there's no benefit in shortcuts. There's no benefit in, if you look at some of the organizations that have existed from time immemorial, it is simply because they have been adherent to corporate governance principles and doing the right thing. Our role as lawyers is to ensure that we assist our clients in keeping on straight and narrow, and let us go forth into the world, ensuring that we preach that gospel and helping our clients remain, because if for no other reason, we will be the beneficiaries of their success. Yeah. So thank you very much.
Thank you as well. Over to you, Jean. 30 seconds, your parting shot. And then we'll finally go to Mr. Ian Mutibwa.
Thank you, Elizabeth. I may say that currently we've seen many investments converging to our region, and one of the requirements to be a recipient of such investments is to have in place a good corporate governance, or to have in place good corporate governance practices. So it's up to us lawyers to advise our clients to be in order, so that we can continue benefiting from such investments. But we also have to bear in mind that it's our responsibility to assist our corporate clients to be compliant with corporate governance requirements, and it will be good for our clients and for us because we'll make more money. Thank you.
Yes, thank you. We go lastly to Mr. Mutibwa.
Thank you, Elizabeth. The beauty of coming last is that you can say everything has been said, but I will not say that. What I would say is that many times we'd like to speak about things in a colorful way when we're not doing them ourselves. I know many of the people here are lawyers, and you're wondering, can corporate governance be applicable in a law firm, or it's just only for the multinational corporations? I will tell you that a law firm, like any business, also requires corporate governance. Most times the partners are the shareholders and the directors, they're the ones doing everything. So even in your law firms, if you're a lawyer, you need to actually embrace these corporate governance practices. What we've done at Signum is create a semblance of non-lawyers, actually not non-lawyers run our business. We are the shareholders. We are here day-to-day shareholders, but we have a team of non-lawyers who run the business part of the law firm. They understand and they know what it means to run a business. They're accountants, they're people doing MBAs, the ones running the business side of a law firm. And why that is important is that you take yourself out of the day-to-day, take yourself out of the management of what you need to do and give people who actually are seasoned in these things to run the business for you. So my parting shots would be, as lawyers, can we also embrace what we tell our clients to do on a day-to-day basis? If we don't, then we'll not understand it so well to be able to give the best advisory for our clients. Thank you.
Thank you very much, and thank you to all of you. And I'd also like to thank the attendees for today for taking part in this webinar. Actually, this is our first inaugural webinar as the Corporate Law Committee, and we thank you for taking your time in the afternoon to come and join us, and also to learn from our various panelists. I believe we've all learned something. Now, I'd like to hand over to Gabriel Achaya from the Secretariat to wind up for us. Thank you.
All right, thank you so much, our esteemed moderator and chair, Elizabeth. It's really been quite an insightful session, and I believe that participants have learned quite a lot. To you, our esteemed panelists, it's been quite an honor to have you on this panel. And we know your time is precious, and as such, we are immensely grateful that you are able to carve out some time for us and making this webinar a huge success. We look forward to learning from you all at future events, and we hope that we get that request. To you, our esteemed participants, it's indeed an honor to always have you every week, consistently attending our sessions. We do not take it for granted. We are grateful that you spare time to come and learn with us. So on behalf of the Secretariat, I would like to thank you all for this wonderful session. Congratulations to our Corporate Law Committee for putting up this very stellar session. Just one announcement from the Secretariat. We will be sharing a recording of the session for your information. You can always listen in to just pick one or two things that you could have missed in the course of the discussions, but we'll also share with you certificates of attendance for this particular session. Would like to inform you that this week we'll be having another session on chatbox, blockchain, and AI and other emerging trends in the financial services industry. So please, if you have not yet registered, please register for that session. We have quite distinguished panelists from across the region who will be sharing their insights on these emerging trends in the financial services industry. So from us to you, have a lovely afternoon. We look forward to hosting you again. Please check out our website if you would like to get more information about our capacity building sessions, but also more information about our physical training sessions, which will be kickstarting in the month of June. So we look forward to having you participate, and have yourselves a very lovely evening until we meet again on Thursday. Goodbye.